Adam, Jessica was talking about the need by the prosecution to link Trump to this scheme and this building brick by brick. Is this getting to that? In other words, is there enough so far to link Trump with the scheme?
So they've made important progress, which is they've now, through Michael Cohen, directly linked Trump to these false payments. The payments were false. The records were false. But there's still a key part which is missing, which is, did Trump direct the entry of false records? Because there would have been no problem had they just put records down that said, we're making hush money payments, and recorded the checks, recorded the ledger as hush money payments. Nothing illegal about a hush money payment. The key part that is still missing here is whose idea was it to do the cover-up in the records, to falsely record the ledger, to falsely record the checks?
So what does that legally mean?
Yeah, so I've been thinking about this over the last couple of days, and I think it's a really significant point that Adam brings up. As a defense attorney throughout the trial, I've been just sort of thinking, riffing on what would the defense explore during closing. And I think this might be something you'll see, which is, and it may sound hyper-technical, but you never know what jury might be interested, what member might be interested in this argument, which is when all this evidence is in, what you have is documents with Alan Weisselberg's handwriting on them.
Right.
You have Michael Cohen's invoices. You have people in the Trump organization who are not the defendant, who are actually making these false entries. Now, if you're out there and you're thinking, oh, come on, it's obvious he was involved,
but
I'm with you.
Let me interrupt
I
you
understand.
for a second, though, Danny, because you do have Donald Trump's signature on some of these documents. Right now, they're just putting before the jury this check and a stub, and the Hoffinger, the prosecutor, asking, did you receive this check and stub as a result of a false invoice? Cohen, yes. And Hoffinger points out, whose signature is on the check? Cohen. Donald J. Trump. Hoffinger, was that a false description of the check stub? Cohen, yes, ma'am.
Yes. So when you have checks, you can't deny that's Donald Trump's signature on there. But you're thinking as a defense attorney, you get up there and you argue, hey, obviously, these are checks, but when you look at the ledgers, you look at the emails that they've introduced, none of those are between Donald Trump. He's not a name on there. Now, everyone will say Donald Trump intentionally doesn't use email for exactly this purpose. That's a gangster move, to never be on the text messages, never be on the emails, so that you're never in trouble. I get it. I'm saying that this may be an argument that might carry weight with one or more jurors. The vast majority of them may say, come on, give me a break. He's obviously involved. He's a micromanager. Fair point. That may be true, but you never know what a member of the jury will seize on. You never, ever know. And by the way, most of the time, you're shocked when you find out what they did seize upon.
There was testimony, though, from Cohen yesterday about this meeting that happened inside Trump Tower with Alan Weisselberg and Donald Trump. And let me just read you this brief chunk from it. Hoffinger says, what, if anything, did Mr. Trump say at the time? And Cohen says he approved it. This is where they're talking about specifically how Cohen was going to get reimbursed for the payments to Stormy Daniels. Cohen says Mr. Trump approved it. And he also said this is going to be one heck of a ride in D.C. Hoffinger, and did Mr. Weisselberg say in front of Mr. Trump that monthly payments would be, like a retainer for services? And Cohen said yes. So, Cohen is putting Trump in the room with Alan Weisselberg, approving the reimbursement payments. Jessica, is that enough?
So, yes, I think it is, in the sense that it establishes that Trump knew how these payments were going to be recorded in the books and records of the Trump organization as payment for legal expenses, when in fact there were no legal services rendered to justify the payments. But again, I think that Danny's point is well taken, which is that on cross-examination, I think that the defense attorneys are really going to go after this exchange and say, well, wasn't Trump doing other things at the time? You weren't really spelling out for him critically how these were going to be entered. He knew that the payment was going to be made to Michael Cohen. He knew what it was a reimbursement for, but was he really paying attention to how it was going to be recorded? He really didn't care that much about exactly how it was going to be recorded.
Because
that's
how
the critical
it was
point.
recorded is the key issue here.
That's the crime. That is the crime. Now, the reason for why it was being falsely recorded, that is what creates the felony, as opposed to just the entry of the false records, which makes it a misdemeanor. And I think that the prosecution has done a really good job in establishing that the reason for the repayment was to reimburse Cohen for what amounted to a campaign contribution. But when it comes to the actual falsification of the records and linking Trump to it, I think that is the weakest part of the prosecution's case thus far, and it's most dependent on Michael Cohen's credibility.
But Adam, could Trump argue also that, when I said these were legal services, they were paid to a lawyer? We keep hearing that argument from him. Could he argue it's all semantics? These were legal services, a retainer fee versus reimbursements.
I think that would be a bad argument, and I don't think that would resonate with the jury. I think that it's going to backfire that Blanche, in his opening statement for Trump, said these were payments for legal services. These were not payments for legal services. This is not semantics. I don't think that the jury would buy that argument. But I do think that the jury would buy an argument, could buy an argument, as Danny said, it only takes one, to buy an argument that he just wasn't involved in the bookkeeping. Yeah, maybe he signed checks, but he was already in the White House. He was busy. I think that would be a better argument for the jury.
Can I just say this case has been a cautionary tale for defense attorneys everywhere that I swear for my next opening argument, it's going to be, how y'all doing? Keep an open mind, and I'm going to sit down. And now why do I say that? Because I can think of two, Adam may be able to think of more, at least two issues that the defense raised in their opening that are now a problem for them. Number one, claiming that these were payments for legal services. Why say anything? Let the prosecution meet their burden. And the other one was, I did not have sex with that woman, or some variation of that now famous line. Again, now a problem for the defense. Why? Because they've opened because arguably, if there's a conviction and when this case goes up on appeal, the issue of bringing in the salacious sex details of Stormy Daniels, the prosecution will have an argument, hey, they opened the door. And in my experience, take this with a grain of salt from a jaded defense attorney, courts love when defense attorneys open the door because they can say, not my problem, that was your fault, and so can the appeals court too.